Hello and welcome to Business on the Wire. In recent weeks, the controversy has broken out around Twitter and the lines of free speech. Things came to a head when Twitter blocked over 200 tweets and handles that the central government wanted removed from public view. Within hours of doing the block, the social media network then went on to restore some of the accounts and tweets, including the handles of Caravan Magazine and Kisan Ekta Morcha. It's not a new pattern. Over the last few years, the government's decision to block hashtags and Twitter accounts under legal provisions that cover the sovereignty and integrity of India have actually raised questions about the transparency surrounding the blocking process. It's now a logjam. The government warns of serious consequences for Twitter's executives in India, while the social media company reiterates its commitment to balancing the removal of content with the idea of protecting public conversation. In the meanwhile, the Supreme Court has issued a notice to the Centre and Twitter India, and they're seeking responses from them on a petition that seeks a mechanism really to check Twitter content, and this is in quotes, to check Twitter content and advertisements spreading hatred through fake news and instigative messages through bogus accounts, end quote. To understand the issue and where resolution may actually lie, joining me now is Apar Gupta. He's Executive Director at the Internet Freedom Foundation. Thank you, Apar, for joining in and having this conversation with me. I want to do a little bit of context setting first in terms of how this entire thing started snowballing 10 days back and where we're at right now in terms of what the social media platform Twitter stand is and what the government stand currently is.
Purely in terms of a timeline, what happened shortly after the farmers' protest was apparently a order was issued directing blocking on certain user accounts on Twitter. This happened sometime around 29th towards 1st of February, 29th of January towards 1st of February. And we don't know the precise dates or the frequency or whether it was just one legal direction because there's a huge amount of secrecy. So this timeline also is open to correction subsequently. However, what happened was that certain accounts came to be suspended on Twitter, which is when public first noticed that, hey, a lot of accounts which have been tweeting around the farmers' protests are suspended. They shortly go back online, and all of a sudden news reports start emerging that Twitter has refused to comply with certain government directions for blocking of user accounts. Subsequent to that, what comes to pass is that there are meetings between representatives of Twitter and the Ministry of Electronics and IT. And also, in addition to that, there is a fresh direction issued under the same law, again, not made public, directing a blocking of about 1,200 odd accounts. And the first one was for about 250 accounts. But we can't be sure of the numbers, the reasons, or whether they are accounts or individual tweets. What we have in the public domain in terms of verifiable information are two pieces. Firstly, a blog post by Twitter saying and setting out its reasons for refusing compliance with the government direction. And secondly, a response by the Ministry of Electronics and IT, which states that this refusal and subsequent meetings with Twitter are essentially a affront to the directions issued by the government. So what we have is some degree of confusion which arises from secrecy, but also some indeterminacy in terms of what will be the next steps in this ongoing tussle between a large social media platform which is not based in India, which is global, and has resisted for the first time directions issued by the Ministry of Electronics and IT.
It's not the first time though, right, Apar? I mean, we've been tracking this, as I have, said in my opening comments as well, for the last 4 or 5 years now. And I think the crux of this messy or opaque situation comes down to that one particular piece of law, if you want to call it that, which is Section 69A. I think that's the one where the big question mark lies, right? So let's break that up for people who are watching and trying to understand. First of all, what does Section 69A state?
Section 69A is the power of the central government to issue directions to intermediaries for blocking any kind of computer resource or information on a network. So ordinarily, it has been orders which have been passed by the Ministry of Electronics and IT, which is the specific uh, ministry, and it has a committee which is established for the examination of blocking directions. So they can be issued to internet service providers like Bharti Airtel, or to Reliance Jio to block specific websites, or to social media companies like Twitter or Facebook to block individual pages or user accounts. These directions have been issued frequently, even prior to this law being there, without any clear legal power. And the government has always sought to block websites in India. This law was inserted in the year 2008 in the Information Technology Act, 8 years after the Information Technology Act was originally made. This amendment was inserted without any discussion in the Indian Parliament, alongside 23 other amendments to laws. And the process for operationalizing this legal power, which is under Section 69A of the Information Technology Act, has been through the block rules made in 2009. No public consultation or stakeholder inputs were invited over these blocking rules. And actually, the provision of secrecy is within Rule 16 of the blocking rules in the 2009, which fleshed out the process.
Hmm. That's the question everyone's asking, right, Apar? I mean, why so much secrecy in terms of what it is that the communication going out to the party is, and why is there no communication from the parties that are affected either? Because the lines are quite strong.
Yes.
You're talking about attacking the sovereignty and integrity of India. You're talking about, attacking the
Yes.
security of the state. In that case, should there not be more transparency about what it is that the government has a problem with?
Exactly. So we've also noticed certain sporadic blocking of websites in the recent past, which make completely no sense, even completely delinked to the farmers' protest. So it was for some time related to blocking for the search engine DuckDuckGo, which is a privacy conscious search engine as an alternative to Google, or the blocking with respect to also WeTransfer, which is actually a European company for transferring large voluminous files, often shared by video creators into GBs. And in all of these instances, the website blocking process and the opacity has come front and center. The opacity and the justification for the opacity may be that the requests, and I'm speculating here because there was no legislative debate, going back to what I said. There was no publication, so we don't even know the reasons why this is being caused. And this is, in fact, a variation from any kind of censorship which is caused even under the reasonable restrictions, which are fairly broad and subjective. For instance, if you censure or ban a book, under the legal provisions, a gazette notification with reasons needs to be published by the state government. If you prohibit any kind of press publication under Section 144 order, public proclamation and notice needs to be made. But with respect to internet censorship, we have this uh, exceptionalism in which secrecy thrives. Maybe because it's just been so easy. Maybe because the government does not want to give reasons for each one of the 240 or the 1200 accounts it's seeking to block. So it's much more convenient. It reduces its work. Another justification, and again, I'm speculating, maybe that there's the what we call the Streisand effect. That if you block content on the internet, it has a way of reappearing because quite often people crowd on social media and start posting it in different contexts and quite creatively. So it kind of defeats the purpose of censorship itself. But all these justifications do not give any support to what is the exercise of a power which in fact undermines our fundamental rights to free expression, undermines the rights of creators and users to actually present their defense, get a copy and order, and also avail legal remedies. Because without the order, you can't even go to court.
Yeah. Uh, it's also a very frequently used tool, is it not, Apar? I mean, we don't have enough data, but for example, what we have from, say, the Lumen website, the Lumen database, I beg your pardon, it indicates that from
Yes.
the period of 2017 to 2020, on an average, Twitter received a Section 669A order every once in 3 months. Do you have more color to add to that
Yes.
data?
Yeah, and here's the thing: it's only Twitter which is populating the Lumen database. Some other intermediaries are also populating it, but Facebook is not sending the requests. A lot of other platforms are not sending in the requests that they are getting. So you're only seeing the user accounts with respect to Twitter rather than the larger category of what would be website-based blogs by itself, or user accounts on Facebook, which is the most predominant channel for dissemination or user adoption of digital content in India even today. One should also not forget that this is the same power which was used to quote unquote ban the quote unquote Chinese smartphone applications,
Yeah.
which all had a distinct area of operation, business entities under a common rationale. So irrational censorship, website blocking is growing due to this threshold problem of secrecy and opacity.
Hmm. So here's the main issue, which is 69A as we see it. Let's discuss some of the surrounding issues on this entire topic apart. The first one, as you mentioned,
Yes.
is on freedom of speech.
Yes, yes, yes. So, quite clearly, Section 69A was noticed as a faulty piece of legislation very immediately. In fact, I was representing the People's Union for Civil Liberties as a lawyer in the larger challenge around Section 66A, which led to the judgment in Shreya Singhal versus Union of India in 2015. In that judgment, Justice Naraman, speaking for the Honorable Supreme Court, actually distinguished Section 66A, which was a provision of criminal law used quite frequently, abused quite frequently, because it was vague to not only prosecute people criminally, but also in some cases arrest them. So the court struck it down. But at the same point in time, the court, when it looked at Section 69A, the power to issue directions for blocking, not with respect to any kind of criminal process which should immediately flow, the court stated the consequences are basically much more innocent. It does not result in a person being faced with a possibility of going to jail. It's just asking a large intermediary, such as a internet service provider, telecom company, or a Silicon Valley giant, to block a specific user account. And if somebody doesn't like it, they can always approach court and challenge it. The last bit never made sense to me, because if the order is secret, how can one go to court and challenge it? And on freedom of speech and expression, this constitutes a very core injury, because we should remember two other things. One, the number of internet users in India has risen rapidly. In fact, the reports from the Telecom Regulatory Authority of India show for the first time there are more than almost, we are at a tipping scale in which there may be more internet connections for every 100 people than anytime ever before. It's almost to a 1:2 ratio, in which there may be about 53 to 54 connections for 100 people in India. The second is that all our media and all our digital India push and all this growing digitization in Indian society is impacting media distribution in a very core and vital way. And this comes through very clearly with this blocking direction, for instance, which has also been made against the Caravan's account by itself, which impact not only the publishers, the editors, the writers of Caravan, but also the readers. And the readers quite often happen to be on social networks rather than on any other place. So you draw them in through these social networks. The injuries are very, very clear. The process is deficient, and Section 69A remains problematic.
The second issue that arises apart, as and you made the point about Caravan India, is the proportionality argument about blocking a
Yes.
specific tweet or blocking a specific hashtag that is deemed inappropriate for whatever reason, versus blocking an entire Twitter account. Now, just to play devil's advocate, I know that the government's point of view is, how do it's messy to sort of divide from what is bad and good content, and maybe in the stream of some good content, some bad posts are layered in, which is why the entire account should be blocked. How does one approach that argument?
I would say one approaches that argument through the test of proportionality. The government is a government of laws. It's formed under the constitution, and the proportionality doctrine is something which is saying that the restriction on a person's right needs to be proportional to the democratic objective which is to be achieved, and needs to be in the least manner uh, uh, needs to be invasive in the least manner possible. So essentially, you don't impose curfew after 8 p.m. because there are high chances of petty crime in an area. You in fact look towards firstly alternatives which don't injure people with respect to their fundamental right to freedom of movement by installing street lights and doing proper police patrolling. And secondly, you don't impose a complete curfew ever, right? And this is what's happening here. So I think the proportionality argument is something which the government should consider within the censorship apparatus itself. It's not as if there's a core principled objection as to the government never being able to block any website whatsoever. However, it needs to be a specific exercise of that power which accounts for a degree of transparency, natural justice, which means that the people who are impacted need to be given an opportunity of leading a defense as well as a legal remedy. And initially, the legal examination of these blocking requests need to be on a constitutional touchstone, because the government essentially carries the highest duty of abiding uh, uh, and in fact safeguarding our fundamental rights rather than just being viewed as a entity which undermines them.
In the course of you tracking this entire sort of blocking account phenomenon, apart, has there ever been an instance where there has been a show cause notice issued to the party concerned, or any opportunity given to the party
Yes.
concerned? There has, but that was not used this time.
No, it was not. So essentially, there's tremendous vagueness also in the procedure, which are the blocking rules of 2009. They say user who hosts the information or the intermediary. So sometimes the ministry is able to identify who's the owner of the website and does send them notices. And then the owner does come forward. However, these kind of processes adopted by the committee for the examination of requests is sometimes lacking. There's also a two-step process here. In emergent situations, it may issue a direction to block a website or a user account first, and then call the person for a hearing, which may have happened in this instance. But quite often, it's calling intermediaries such as internet service providers or Facebook or Twitter before it, rather than the actual owners of the account. And it's quite easy to actually identify Caravan because they are a registered trade publication, and just an ordinary search will reveal who are the proprietors and the editors, and they can come and lead a defense. Secondly, this process which has been adopted has been implemented in a very ad hoc manner. So there's vagueness in the operational rules. Secondly, the practices which are being put in place are also fairly varying from time to time, from person to person. There is one case, for instance, in the Delhi High Court, which lawyers at the Internet Freedom Foundation are assisting and supporting, which concerns a block on the satire website called Dowry Calculator, which was created by a film critic Tanul Thakur. And it essentially was blocked because one opposition MP at that time, Mr. Jyoti Raje Scindia, tweets to a minister in the government, which is Srimati Maneka Gandhi, and on the issue of dowry and how this may end up promoting dowry, missing the obvious point of parody. And she marks it down to her colleague, Mr. Ravi Shankar Prasad. And we know all of this chain through RTIs. But even then, when we go to court and we ask whether was a show cause notice and a hearing opportunity given to Tanul Thakur, the answer is no. And we also ask, where is the actual text of the order which you eventually passed against him? Again, it's not available, it's not public. So, even for creators and owners of these accounts, the legal remedies are not very clearly established, and they're essentially faced with a very Kafkaesque kind of censorship in which there's quite often guessing, why was my website taken down or blocked? Is it a technical error or is there a legal reason behind it?
Hmm. There's another point which some tech policy watchers have made apart, which is that, what is this conversation and consultation with Twitter about? I mean, for example, if they have violated something under the section
Yes.
of the law, just take action. The
Yes.
government should take action and, follow the next step of process of law. Why are we inviting them for consultation and discussion? I'm curious to know where you stand about that point.
So, my belief system has always been that consultations which are done in good faith but are done transparently, in which minutes of meeting are published by government, are actually not something which is anti-democratic. It is when conversations take place in closed doors and certain compromises are reached which impact the public sphere or our fundamental rights on a platform like Twitter is when it becomes problematic. So the press release which has been put by the government may constitute some degree of transparency, but it is not an alternative to knowing who were the officers who were in that meeting, what were the documents which were exchanged, and what were the minutes of those meetings by themselves. So the the action which some tech policy watchers may be thinking about is the non-compliance of Section 69A. And then for the non-compliance of Section 69A, there is a term of imprisonment which may result after a criminal trial for a period of about 7 years. So it's a very tough sanction. I think the government is also thinking twice before proceed further ahead.
Mm. There's another tricky point which came up through Twitter's communications apart, which is that they took the line of jurisdictional defense, saying that we're governed by U.S. laws, so we're not really covered by Indian laws. Now, this is tricky territory to get into for that platform, is it not?
It is, I think, Twitter is governed by the laws of India under the Constitution of India. It provides access to a large number of people here. It should definitely comply with our laws. But if those laws by themselves are not exercised in a constitutional manner, then of course Twitter can make a decent argument against the compliance of any such direction. Again, it's an imperfect stakeholder. It's a large Silicon Valley corporation ultimately serving shareholder interest for profit, which is based on an economic model in which it gathers greater amounts of personal information from all of its users and then sells it to marketers, which has its own distinct area of concern. So, by all measure, Twitter is not something which is a public charity or something which can be termed as a public defender for freedom of speech and expression, right? But at the same point in time, the principal fault falls to the government because it is making Twitter to be the public defender and ultimately not adopting its measures with a degree of transparency, which would also aid in a higher degree of user trust, citizen trust in the kind of actions it's taking and the censorship it's demanding.
Hmm. What are the options present before Twitter at this point apart? Because that also seems to be the observation that this time round they've chosen to draw a line in the sand and say, here's where we stop in terms of freedom of expression, and we are going to support it, and we do want the free flow of tweets, as they said. Can they disregard this and move court?
I don't think so. I'm talking now much more from a personal assessment. This is not professional advice, but I think it would be. I think moving court at this instance would be a bit premature because the issue becomes legally ripe when a FIR is registered or where a criminal complaint is sent by the Ministry of Electronics and IT.
Yeah.
Right now, what Twitter has done is that it's gotten a direction. It has complied with that direction, which is an emergency blocking request from what it seems, right? And then gone back to the committee, given its reasons why it is unblocking those accounts. And not all accounts are being unblocked. Certain are being unblocked and certain are not being unblocked. So it's basically making a distinction also. And then it's making arguments on the basis of reasonableness and proportionality. Natalia, I'm gathering all of this on the basis of news reports, offhand source comments, and in addition to that blog post made by them. But we lack very material information around a lot of this. I think at this stage, it's for the government to clearly state where it stands and what it intends to do further. In fact, from where I sit, I do not think so there is any occasion for Twitter to go to court at present. It may not choose to do so, but I don't think so. Till a criminal complaint is registered or a FIR is registered, it has the fullness of a legal standing to approach a court and challenge a government action.
So then let me ask you this. How do you think this will resolve itself? Because one sort of expected line apart is that the government and Twitter talk. As you said, a couple of those handles are blocked, but the more important ones, if you want to call it that, are not. The issue gets resolved, public memory fades, and you're still sitting with the Section 69A problem. But this one has been sort of kicked down the can. Is it your sense that's the way it's going to go, or is it this time it's different feeling?
I can only say I. So yeah, that's my feeling. Unfortunately, and that's why structural problems persist because we look for short compromises, and it's not to indicate fault to or blame towards any specific company. It's just how structures work. It takes a large amount of energy and sustained public advocacy to get these laws changed. I think for the first time, at least, we've had a very public conversation about website blocking because this power has been used so frequently for a whole set of blocking orders, which range from very diverse concerns. It's not only about sovereignty, integrity. Sometimes it's about assertion of copyright claims, which are made very rationally over websites which have no connection to ownership interest, and the entire website is blocked. It's made against websites which also publish what may be termed as quote unquote obscene content, even though there's no power under Section 69A to block obscene content under grounds of morality or decency. So the Savita Bhavi website was blocked under this provision, and in fact, Manoj Mitta in a front page article in Times of India said that the government did not even have the power to issue that direction. This was sometime in 2012. So I think the focus now, hopefully, even after the Chinese smartphone app ban, is on Section 69A, the lack of transparency, and we've seen this entire controversy rage for about close to 10 days. I think it's also set a positive precedent in a very limited manner in which social media companies asserting a defense on behalf of its users with respect to freedom of speech and expression. It's not the ideal outcome because I don't think so. Social media companies make for the best stakeholders or advocates for our fundamental rights.
No, absolutely. I agree with you wholeheartedly. And I think if we are having this conversation about toxic content, there is a lot of toxic and harmful content out there on social
Yes.
media platforms that we need to address. Thank you so much, Apar. Really appreciate your chat today. Thanks so much for joining in and speaking with me.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.